All right, so today we're diving into something that's been making a lot of noise, the Expropriation Act of South Africa.
Right.
We've got two big documents in front of us, the Act itself and that South African Constitution, and we want to see how they fit together,
Okay.
especially when we think about land reform and individual property rights.
Yeah, it's an interesting puzzle, right? You've got this huge need for social justice and a history of land dispossession.
Right.
And then you have this constitution that's all about protecting those individual rights.
Exactly, and that's what makes this deep dive so fascinating. So to get what's going on with the Expropriation Act, we got to start with the Constitution, right?
Yeah.
Like laying the groundwork before you build the house.
Absolutely. And the cornerstone of that foundation, at least for property, is in Chapter 2 of the South African Constitution.
Okay.
Section 25. It's the part that deals with property rights and how the government can expropriate property.
Okay, so it's not just a free-for-all.
Right.
The government can't just come and take what it wants.
Yeah. Not at all. Section 25 lays out very specific conditions that have to be met. First, any expropriation has to be in line with the law of general application.
Okay.
So there needs to be a clear legal framework, not just random seizures.
Yeah, it has to be lawful. So what else?
It also has to be for a public purpose or be in the public interest.
Okay, but that's pretty broad, isn't it?
You're right, it is. But here's where it gets interesting. The Constitution itself defines public interest to include the nation's commitment to land reform and to reforms that bring about equitable access to all of South Africa's natural resources.
Wow, so they're connecting property rights to these big goals of social justice and making up for past wrongs. It's like they're saying we value individual property rights, but we also have to acknowledge the past
Right.
and work towards a fairer future for everyone.
Yeah, that's a good way to put it. It's about balance. And it's important to note that this idea of addressing past injustices is also in the Constitution's preamble, which talks about healing the divisions of the past and making a society based on democratic values and fundamental human rights.
So the Constitution is setting the stage for a nation trying to move forward, but still carrying the weight of its history.
Exactly. But even when expropriation is for the public good, the Constitution demands just and equitable compensation for the property owner.
Okay, let's break that down. Just an equitable compensation. What does that mean practically? Is it just market value or is there something more to it?
That's the million-dollar question, and probably one that'll be debated for years to come. The Constitution lists some factors to think about, like market value, the history of how the property was acquired and the purpose of the expropriation, but it doesn't give an exact formula.
So you can't just look up the property value online?
No, not at all.
Like,
Imagine a piece of land taken from a family generations ago because of discriminatory laws. The market value today might be high, but how do you factor in that historical injustice? What would be just in that case?
yeah, that has layers of complexity, and I bet there are people with strong opinions on both sides of this.
Absolutely. The Expropriation Act, even though it's meant to work within this constitutional framework, is still a hot topic. Some people say it's essential for land justice and fixing the legacy of apartheid, while others worry about the government having too much power and property rights being eroded.
So how does the Act itself tackle this whole process? I'm curious how the Act's specifics line up with these broad constitutional principles. Does it try to find that same balance?
Well, one thing that jumps out is the focus on making sure the process is fair. It lays out a very detailed process that has to be followed before expropriation is even considered.
So the government can't just snap its fingers and take someone's property.
Right.
There's a system.
Exactly. For one thing, the Act says the authority doing the expropriating has to try in good faith to reach an agreement with the property owner before they resort to expropriation.
Okay, so negotiation is the first step.
Right.
It's not just about taking.
Yeah.
It's about finding a solution that works for everyone.
That's the idea. It underlines that expropriation should be a last resort, not the go-to. And the Act goes into a lot of detail about what these negotiations should look like, what information needs to be shared, and what happens if they can't agree.
Okay, so they're trying to build in safeguards and make sure it's fair and transparent, even if it does end in expropriation.
Right. And that's where some of the Act's more specific details come in, things like having to have public notices about expropriation, the languages they have to be in, and even how they have to be published.
I'm guessing these details are important because they make sure everyone knows what's happening and can participate.
You got it. The Act is trying to avoid a situation where someone could say, I didn't even know this was going on. They're trying to make sure everything's above board and everyone's voice is heard.
So we have this big picture from the Constitution, and then the Act comes in and fills in the details, adding in process and safeguards. It's like a blueprint for how expropriation should work in a society that's fair and just.
And that's what makes it so interesting. We're not just looking at legal jargon. Right.
We're seeing how a nation tries to bring its past and its hopes for the future together. And the Expropriation Act is right at the center of that.
All right, so we've laid the groundwork. We've got the Constitution as our foundation, and now we're starting to see how the Expropriation Act builds on that with its focus on process fairness.
Right.
And that crucial balance between individual rights and the public good. I have a feeling this is just the beginning, though, right?
Oh, yeah. We've barely scratched the surface.
Yeah?
Next, we'll dig even deeper into the Act itself, looking at some specific parts that might be relevant to you, our listener. We'll look at how the Act handles things like compensation deadlines and what happens if there are disagreements along the way. We'll even look at what happens if they can't find the property owner. Stay tuned, because it gets even more interesting from here. Okay, so let's pick up where we left off. We were talking about all those safeguards built into the Expropriation Act.
Right, those procedural safeguards.
It's clear they really tried to make it fair and transparent. Yeah, it's like they took those constitutional principles of fairness and due process and made them into a step-by-step guide for how expropriation should actually work.
Exactly. And it's not just about checking boxes and following procedures for the sake of it.
Right.
They're there to protect people's rights and make sure everyone's treated fairly.
Now, we talked about the Constitution's focus on just and equitable compensation.
Yeah.
But how does the Act itself actually deal with that?
Right.
Does it give any more specific guidance?
Well, it doesn't define those terms explicitly. But remember, the Act is designed to work within the framework of the Constitution.
Okay.
So it might not give you a formula for calculating compensation, but it acknowledges that constitutional requirement for fairness and equity.
So the Constitution sets the principle.
Yeah.
And the Act provides the practical steps, but always with that principle in mind.
Exactly. And that's where the courts come in. Ultimately, it's up to them to interpret and apply the Act in a way that's consistent with the Constitution's guarantees.
So even though the Act might not have all the answers, it's part of a larger system designed to protect those rights and make sure things are fair. It's like a checks and balances system.
That's a great way to think about it. And legal systems are always evolving. So as cases come before the courts, we'll see a body of legal precedent develop that'll help clarify what just and equitable compensation means in different situations.
So it's not a static thing. It's something that's going to be shaped by real cases and interpretations over time, which makes it more interesting, but probably also more confusing for people trying to figure out how it all works.
Yeah, it is a lot to wrap your head around. But the key is that the Act is meant to work within this larger constitutional framework.
Speaking of specifics, I'm intrigued by this idea of material errors we touched on earlier. How do you even determine what's material in something as complex as expropriation?
Well, that's where legal expertise comes in. You probably want to talk to a lawyer who specializes in this area to get a truly informed opinion. But generally speaking, a material error would be something that really impacts the fairness of the process or the outcome.
So like a typo in a street address on a notice probably wouldn't derail the whole thing, but failing to notify a property owner altogether would be a big problem.
Exactly. It's about understanding the intent of the law and figuring out whether an error undermines those basic principles of fairness and due process that the Act is supposed to uphold. Remember, the Constitution says everyone has the right to administrative action that is lawful, reasonable, and procedurally fair.
Okay, so it's not just about dotting your I's and crossing your game. It's about making sure the process is genuinely fair and equitable, even if there are little hiccups along the way.
Right. And this brings us to another interesting part of the Act, which is recognizing that even with the best plans, things don't always go perfectly. There might be situations where it's impossible to stick to the original timelines. Think about it. You might need more time to gather information, consult with experts, or address concerns that come up.
Okay, so what happens then? Does everything just stop?
Not necessarily. Section 19 of the Act actually lays out specific times when the expropriating authority can ask for an extension to those timelines.
So it's like a safety valve to keep the system from getting too rigid and allows for some flexibility when it's needed.
I like that analogy. But remember, these extensions aren't just automatic. There are conditions. For example, there might be delays that are outside the control of the expropriating authority, like waiting for info from another government agency or dealing with unforeseen events like a natural disaster.
So things that are truly out of their hands. What else?
Another good reason for an extension is if there needs to be more consultation with the people affected. Let's say a community raises concerns about the proposed expropriation. The authority might need more time to address those concerns, gather feedback, and see if there's a way to find a solution.
It's interesting how the act balances the need to get things done efficiently with the importance of giving people a chance to be heard.
You got it. It's not just about rushing through the process. It's about doing it right and making sure everyone's rights are considered.
We've talked a lot about how the Constitution shapes the Expropriation Act, but does the act ever actually directly reference or quote the Constitution?
Okay.
Is it more of an unspoken connection, or are there explicit links?
Oh, there are definitely explicit links. It's not just implied. The Act directly references key parts of the Constitution to reinforce its commitment to those constitutional principles.
Okay, give us some examples. What kind of connections are we talking about?
Well, right in the preamble of the Expropriation Act, it explicitly mentions Section 33 of the Constitution. That's the part that guarantees everyone the right to administrative action that is lawful, reasonable, and procedurally fair.
So right from the start, the Act is acknowledging that it has to operate within the boundaries of procedural fairness as defined by the Constitution.
Right. And it goes on to mention Section 34, which gives everyone the right to have their legal disputes decided in a fair public hearing before a court. Again, this underlines how important judicial oversight is and the right to challenge decisions.
Okay, so the Act isn't just some random law operating on its own. It's tied directly and explicitly to the core principles of the Constitution. And these aren't just passing mentions, right?
Right.
They actually affect how the Act is used.
Absolutely. For example, remember when we talked about needing to try in good faith to reach an agreement with property owners before resorting to expropriation?
Yes, it seemed like a really important first step in the whole process.
Well, that's actually written into Section 3.2 of the Expropriation Act. But if you look closer, you can trace that principle back to Section 25.3 of the Constitution, which talks about needing either an agreement or a court decision on how much compensation should be paid and how...
Growing, the Act is taking the Constitution's big ideas and turning them into actionable steps, putting principles into practice.
Right. And it shows how interconnected the legal system is. It's not just a bunch of separate laws. It's a whole web of principles and procedures all working together.
Speaking of interconnectedness, what about the connection between the Expropriation Act and those overarching goals of social justice that are so central to the South African Constitution?
Right.
We touched on this before, but I'd like to explore it a bit more.
It's a key point. Remember the Constitution's preamble.
Yeah.
It sets the stage and says the goal is to heal the divisions of the past and make a society based on democratic values, social justice, and human rights.
And it sounds like the Expropriation Act, with its focus on land reform and fair access to resources, is meant to help achieve those goals.
Exactly. It's not just about expropriation for the sake of it. It's about using this legal tool to fix historical injustices and make sure land and resources are distributed more fairly.
So to really understand the Act, you can't just look at it by itself. You have to see it within this broader context of South Africa.
Absolutely. And that context is always changing. The debate about land reform, about what's just and equitable, about balancing individual rights and what society needs, that conversation is still going on in South Africa.
And the Expropriation Act is right in the middle of it. It's not just a set of rules, it's a dynamic law that will continue to be interpreted, debated, and maybe even changed as South Africa deals with these complex issues.
And that's a really important thing for our listeners to remember. Even though we've talked about a lot today, this isn't the final word on the Expropriation Act. It's more like an invitation to keep exploring, to be part of the discussion, and to form your own informed opinions about this complex and evolving issue.
Knowledge is power, right? The more you understand the law, the better equipped you are to participate in these conversations.
Absolutely. Understanding the law, especially laws as impactful as the Expropriation Act, is crucial for being part of a democratic society.
Okay, I'm ready to get into some more of the specifics. What else stands out to you in the Act? What else should we look at?
Let's talk about Section 22. This one gets right to the heart of those checks and balances we were talking about earlier.
Okay, remind me, what's Section 22 all about?
This section says that individuals have the right to go to court to challenge any part of how the act is being used.
So if someone thinks the process isn't being followed correctly, or if they feel like their rights are being violated, they can fight back.
You got it. It's a crucial protection against the potential for abuse of power. It makes sure the expropriation process isn't just a rubber stamp, it's subject to judicial review.
So the courts are like the referees, making sure everyone's playing by the rules and that everything's fair.
That's a great way to put it. And this is really important for you to understand. Whether you're directly involved in an expropriation process or just interested in how this act might affect you or your community, knowing that you have the right to a lawyer and the ability to challenge decisions in court is powerful.
It's like having a safety net. even if you hope you never have to use it.
Exactly. And it reinforces the idea that the law isn't some far-off abstract thing. It's a system you can engage with, shape, and use to protect your interests.
I'm really curious about these public notices about expropriation. The Act gets really specific about this, right?
It does. It's a great example of how the Act tries to be fair and inclusive even in the bureaucratic details.
So what are some of the key things? What makes these notices special?
Sections 11 and 12 are where it's at. First, the Act isn't just about making sure a notice exists. It's about making sure the right people actually know about it. It's about access to information.
That makes sense. What good is a notice if no one sees it?
Exactly. So the Act says these notices have to be published in a way that's likely to reach the people affected. This includes using multiple languages, English, plus any other official language that's common in the area.
That's important, especially in a country as diverse as South Africa.
For sure. The Act recognizes that language can be a barrier. So it tries to fix that by saying they have to be published in multiple languages. And it's not just about language either. The Act says the notices have to be published in newspapers. 2 of them, in fact, and in different languages. And these have to be newspapers that lots of people read, not just small publications.
So they're really trying to spread the word and make sure everyone gets the information.
Right. They're trying to prevent someone from saying they didn't know about the process because the notice was hidden away somewhere. And it gets even more specific if it's about land. The notice has to be physically posted on the land in a place where everyone can see it.
Wow. Talk about being transparent. They're making it hard to say, oh, I didn't know. But what happens if they can't find the owner?
That's covered too. Section 7 talks about what happens if they can't find the owner or if they don't have the info they need to get paid. It's about making sure everyone's interests are protected even if they're not around or don't respond. They've got a plan for that.
Okay, so they've really thought of everything.
Yeah.
This isn't just some quickly made policy. They've tried to think ahead and build in those safeguards. Now, for our listener who might be thinking, okay, this is all well and good, but what does it actually mean for me?
Right.
Yeah.
That's the question. You've got the South African Constitution, this big document that's all about human rights and social justice. It sets a high standard.
And the Expropriation Act has to operate within that framework. It has to try to strike that balance. It has to recognize the injustices of the past while also providing a way forward where property rights are respected.
Yeah, it's a tricky balance.
It is, and one that South Africa is working through using its laws and institutions to figure it all out.
And that's what I think is so insightful for our listeners. By digging into the details of this act and how it's connected to the Constitution, we're not just getting a law lesson. We're seeing a whole nation grappling with some of the most basic questions of fairness, justice, and what it means to build a more equal society.
Well said. And I think one of the most important things for our listeners to take away is that this isn't a done deal. The way the Expropriation Act is interpreted and applied will probably keep changing as new cases come up, as the political landscape changes, and as South Africa continues to deal with its past and its future.
You're absolutely right. It's an ongoing conversation, and the act is at the center of it.
All right, we're back. And after going this deep into the Expropriation Act, you really see how much thought went into it.
Yeah, it's true. Trying to find that balance between needing land reform and individual property rights is tricky, and they've put so many checks and balances into the system.
Right. It's like they tried to think of everything that could happen and build in ways to make sure the process is fair and open. But even with all that, some people are still going to feel uneasy about it.
Yeah, I get it. Change can be scary, especially when it's about something as basic as property. But remember, the South African Constitution is strong on both social justice and individual rights. The Expropriation Act has to work within that.
So for our listener who's thinking, okay, well, what's the bottom line? What does this mean for me?
I think the biggest takeaway is that South Africa is having a really important conversation right now about land property and justice.
Yeah.
The Expropriation Act is a big part of that conversation. It's meant to address the wrongs of the past and make things more equitable when it comes to resources.
We're trying to fix the past and build a fairer future for everyone at the same time.
Exactly. But it's not a simple solution, and it comes with challenges and potential problems. That's why it's so important to stay informed, understand how this act works, how it connects to the Constitution, and what rights and protections are in place.
Knowledge is power, as they say, especially when it comes to something like this.
For sure. And the act is always being tested and refined through legal challenges, court rulings, and public debate. It's a process that keeps going.
So even though we've gone over a lot, this is really just the start.
Yeah.
It's like a doorway to keep learning, stay involved, and form your own opinions about this complex issue.
Exactly.
So before we wrap up, I have one last question for our listeners, something to think about.
Okay, I'm ready.
How do you think the Expropriation Act will be interpreted and used in the future, especially with all the debate about land ownership and social justice in South Africa? It seems like we're at the beginning of this story.
That's a great question, and it's one that will probably be discussed for years to come.
Yeah.
Remember, the Act isn't just a set of rules written in stone. It's a living document that will keep evolving along with South Africa itself.
It's like a snapshot of a nation going through a big change, trying to deal with complicated issues and create a more just future.
Well said. It reminds us that the law isn't just about words. It's about how those words affect people's lives.
That's a great point. And on that note, we'll wrap up this deep dive into the Expropriation Act. Thanks for joining us on this journey. We hope you've learned a lot about this important piece of legislation.
It was great to be here.
Until next time, keep thinking and stay curious.